Good morning, dear students. Well, actually, this is the second lecture in the field of the penal law. In the first lecture, we have highlighted the syllabus of the course, and now, inshallah, we will uh, cover all of the topics that were shown during the first lecture, which is entitled The Syllabus of the Course, the Penal Law. Well, here the definition of the penal law. And just to remind you, the criminal law has two branches. The first branch is the the objective side or the objective branch of the criminal law, which is the penal law. However, there is another branch, and it is called the law of the criminal procedures, and it is the procedural branch of the criminal law. We will not cover the second branch, I mean the procedural one, during this semester. However, we will focus on only the theoretical or the subjective branch of the criminal law that is entitled the penal law. So here we will define, or we will start with defining the penal law. So the penal law is the body of rules. When we want to define any law, we have to say, or we have to start with defining the law as body of rules, and this is something logical and understood. So it's body of rules which decides the conducts that can be considered as crimes, and also these rules show the penalties imposed to those who commit these crimes. So the rules of the penal law has two important phases, or two important pillars or elements. Number one is that the rules of the penal law, it names the conducts, whether they are commissions or omissions, that they constitute crimes. And number two, it shows the penalties that must be imposed to those people who commit those crimes. Okay, so we have two elements in the definition of the penal law. So the penal law is a body of rules, and these body of rules, they decide what are the conducts that they constitute crimes according to the penal law, the penal code. And number two, they decide what are the penalties that must be imposed by the executive authority on the people who commit the crimes mentioned in the penal code. Okay, now some codes in some countries label these rules, I mean the rules which decides the crimes and the penalties, they label these rules with the name of the penal code. Okay, while others label it with the name of criminal law, or it may be they name it as criminal act. Now, well, actually, both names were criticized. However, we will tell you why these names are criticized in the coming lecture, inshallah. However, you have to know that the legislators around the world, they give different names for this branch of the law. I mean, the theoretical or the subjective branch of the law or the criminal law. So some legislators, they give the name penal code. However, others prefer to give it the name of the criminal law or the criminal code or even the criminal act. Okay, what are the topics or what are the most important topics that are included within the penal or the criminal law. Here he says that the criminal law comprises of the following, or comprises the following subjects. What are the subjects included within the criminal law? I mean, the criminal law as term here, which is adopted by some legislators around the world. It says that the criminal law comprises the following subjects: all forms of crimes. So he says that criminal law as term, it includes the names of the crimes. It means he decided or decides the names of the crimes. What are the conducts which constitute crimes in the society? Number two, the theory of the criminal accomplice means when you do the crime with another person. So the accomplice is your partner or the criminal partnership. Okay. Number three, the criminal intent. Okay. And the criminal procedures followed, and the criminal courts, and the criminal liability. So all of these matters are branches of the law named criminal law. So we can say that this name to refer, or when this name is used to refer to the penal code, is criticized simply because it includes the following. It includes the criminal procedures, the criminal courts, and actually these matters are not part of the penal code. They are only part of what? They are part of the law of the criminal procedures. The law of the criminal procedures. And as we mentioned previously, the law of the criminal procedures is the procedural part of the criminal law. And we here do not talk about the procedural part. We are talking about the theoretical or the thematic, or even we call it the subjective part of the criminal law, which is the penal code or the penal law. So how could we refer to the penal code here with the name of the criminal law, and the criminal law includes the following? So this is why the criminal law as term is criticized if we want to use it as alternative for the law that is called the penal law or the penal code. Okay? So what are the topics of the penal law? The penal law includes the following: all kinds of penalties, the criminal intent, the criminal accomplice, the attempt to crime, cases of irresponsibility, the permissibility cases, the punishment environments. Well, I prefer not telling you the meaning in the Arabic language. However, since it is the beginning of the course and I don't want you to feel perplexed or to feel lost, I would like to give you the meaning of them in the Arabic language, so that uh, when we come to illustrate them in the coming lectures, inshallah, I would like you to know the minimum limit of information about each term. Now, the penalties is easy, so I wouldn't talk about it. The same for goes for criminal intent. However, the attempt to crime, it is the what is called in Arabic الشروع. Okay, the cases of a responsibility بنسميها موانع المسؤولية, and we will talk about it inshallah the next lectures. Permissibility cases, حالات الإباحة, and I told you before, the permissibility cases, they are cases which flips the act from or it turns the act from being illegal one to legal one, simply because there are one of the reasons of the permissibility, or one of the cases of the permissibility, like the case of the self-defense. Like when someone kills another person premeditatedly, then in this case he is committed, or he is accused of the crime of murder. However, if that person killed that, or the other person under the case of the self-defense, then in this case he is not accused of the murder. He commits nothing. I mean, he is not murderer. Why? Because he is under one of the cases of the permissibility. It is called the self-defense. So the self-defense is considered as one of the most known examples about or for the permissibility. Okay, and number three here, the punishment impediments. موانع العقوبة. It means that the person is liable. He committed the crime. The crime existed. It is not it is not vanished due to the permissibility cases. So no cases of permissibility. The crime is existed. It is found. The person is liable for the crime. However, despite the fact that the crime has existed and the person is liable, the legislator wants not to prosecute this person or even to litigate him. Why? Because there is one of the punishment impediments that we will illustrate later, inshallah. So these are the topics of the penal law. Okay, why is the penal law as term is criticized? We will discuss this later, inshallah. However, you have to know, all what you have to know is that the penal law is the subjective branch of the criminal law. Number two, it has many names. So some legislators prefer the wording penal code. However, others give it the name of the criminal law. And we now know what are the branches or what are the topics that every term covers, and why the criminal law is criticized, and what are the topics that are covered by penal law. And now let we move to the other idea mentioned here. What is the name that was adopted by the Palestinian legislature for this branch of law? Now here we are talking about the name of the laws or the penal codes that are applied in Palestine. Palestine geographically and due to the occupation, it is as there is kind of isolation between two parts of the Palestinian territories according to Oslo Agreement. There is the West Bank and the Gaza Strip. There are two penal codes applied in both geographical scopes. Well, the law that is applied here in Gaza is the law of 1936. So, what is the name of this law that is applied here in Gaza? And what is the name that is adopted according to this law? Well, actually, Article 1 of this law, I mean, the Article 1 of 1936 Ordinance, which applied to the Gaza Strip, it stipulates that this ordinance, I mean, the penal law, yani, may be cited as the Criminal Code Ordinance. So the name of the law applied in the Gaza Strip, and it represents the penal code or the penal law as branch of the criminal law, is cited as a Criminal Code Ordinance, the Criminal Code Ordinance. And hereinafter is referred to as this code. So this is the name of the penal code that is applied in Gaza, okay? It is the Criminal Code Ordinance number 74 for the year 1936. I would like to write it here. Well, so it is the criminal ordinance. It's number 74 for the year 1936. Okay, so this is the law that is applied to Gaza. And we have another law which is applied in the West Bank. Let me clear all. We have another law, actually. It is applied in the West Bank. It is called the Penal Code number 16 for the year 1960. It is actually a Jordanian law. It was applied to the West Bank before 1967, and after that, it was adopted by the Palestinian Legislative Council, and it was admitted as the law applied to the West Bank, and it is called now the original code. Well, you have to know that we have only three penal codes. Every one is applied to one of the geographical scope of the Palestinian territories according to Oslo. The first one is the law number 74 for the year 1936, and it is a British law in nature. Historically, it was made by the British mandate. It is still applied in the Gaza Strip till this moment. And the other code is the code number 16 for the year 1960, and it is applied in the West Bank. Okay, so these are the laws applied to Gaza Strip and the West Bank, sorry. Well, now, after knowing what are the laws that are applied, I mean the penal laws applied in the Gaza Strip and the West Bank, we will move to the first important topic in the penal law, which is the legality principle. The legality principle. Well, if you want to search about this name literally, you wouldn't find it. However, you can find it if you put the name or the name in the Latin language. It is Nullum, Crimen, Sine, Lege, and Nullum or Nulla, Poena, Sine. What does that mean? Well, actually, this means that no crime without a law, لا جريمة إلا بالقانون يعني بنص, and nullum poena means no penalty without also a law. So lege, it is a legal text. It means also lex. So lex, it's a law, and lege is a law. So nullum poena sine lege and nullum crimen sine lege means no crime and no penalty without a text. It is actually one of the principles that is adopted within the constitution. Here in Palestine, in the basic law, because we do not have a literally constitution, we have a basic law which runs the function of the constitution. It adopts this principle. It says that no crime without a legal text and no penalty without a legal text. And this is what is called the legality principle. So the legality principle, what is the legality principle? The legality principle is the principle which means that no crime without a legal text and no penalty without also a legal text. Let me now illustrate precisely what do we mean by the legality principle. Well, this principle means that legislature is the only organ who has which has the power to decide which of the conducts is considered a crime, and the penalty shall face the perpetrator of such a crime. Okay? So when we say that no crime without a legal text, who made this legal text, or who makes this legal text? Well, actually, these legal texts are made by the legislator. So the legislator is the one who decides what of the conducts in the society is considered a crime, and if he does so, he must also mention what is the penalty that must be imposed to the person who committed this conduct. So it's logical that every crime shall be connected with penalty. So the text, if it includes only the crime without a penal or a penalty, then it is inchoate one, and it must be removed from the criminal code, simply because the crime must be linked with the penalty. Okay, so to know whether the commission or omission is considered a crime, we have to read the text within the penal code promulgated by the legislative body in the state. So when the government, for example, wants to prosecute person for merely committed or committing a conduct that it is not mentioned within the penal code, this is illegal procedure. This is a null procedure, simply because the conduct that he committed is not named and it is not even illustrated in the penal code. So I cannot prosecute you for committing something or for committing a conduct that is not mentioned or even penalized or even criminalized by the legal text, whether the constitution, the criminal code itself, or any regulation. Okay, so that's what we mean. إن القانون بيقدرش او خلينا نقول بيقدرش الحكومه او المحاكم تقدرش تحاكم شخص على مجرد ارتكابه سلوك الا اذا كان هذا السلوك قد تم يعني وضع تجريم له ووضع عقوبه له في القانون. لا جريمه الا بنص ولا عقوبه الا بنص، بمعنى انه المشرع هو الوحيد اللي بيحدد لي ايش هي الافعال اللي بالمجتمع بتشكل جريمه وايش هي العقوبه المقترنه بها. فاذا كان والله ارتكبت واحد من الأفعال اللي بتندرج ضمن القانون اللي اسمه قانون العقوبات، فإنه حينئذ يعني إذا ارتكبت واحد من هذه الأفعال هي أنت تعتبر مسؤول جزائيا وممكن تتحاكم وتتعاقب. However, if the conduct that you committed is not mentioned in the penal code or any other kind of laws, because the principle says no crime without a text. So the text it is maybe a criminal code, penal code. It may be it is maybe a regulation or the constitution. So all kinds of texts. No crime without a text. What we mean by the text here, not only the penal code, any kind of texts. Okay. So if you committed a conduct that it is not mentioned within these texts, then in this case we cannot prosecute you simply because it's against the legality principle. Okay, let's move to the other ideas here. All of the international conventions and the declarations confirmed on the importance of this principle, like Article 2 of the Declaration of the Rights of Man and the Citizens 1789, the Magna Carta and Article 7 of the International Covenant on the Civil and Political Rights. كل المؤسسات الدولية اللي أصدرت يعني تصريحات، وكذلك الإعلانات والمواثيق الدولية تضمنت مبدأ لا جريمة ولا عقوبة إلا بنص. For example, في عندي Article 2 of the Declaration of the Rights of the Man and the Citizen. It stipulates that no crime and no penalty without a legal text. The Magna Carta, as one of the most important documents, it says that also no crime without a legal text and no penalty without a legal text. Also, the ICCPR in Article 7, you will find the principle of Nullum Crimen Sine Lege and Poena Lege. Also, the Rome Statute constituting the International Criminal Court, it also uh, stipulates that nullum crimen sine lege and nullum poena sine lege, and you will find it with the Latin name. Actually, it is used. I mean, the Latin name is used during within the Rome Statute constituting the International Criminal Court. Also, the Islamic Sharia embraced this principle many decades ago, simply because Allah says in the Quran, and I quote here as translation, actually, it's not literal. Whoever is guided is only guided for the benefit of his soul, and whoever errs only errs against it, and no bearer of burdens will bear the burden of another, and never would be punished until we send a messenger. وما كنا معذبين حتى نبعث رسولا، لأن الرسول مهمته إنه يحدد إيش الفعل الصح وإيش الفعل الغلط، إيش الفعل اللي بيشكل جرم وفق المنظور الإسلامي وإيش الفعل اللي بيشكل الجرم. فهو بيقول لي ما كنا معذبين حتى نبعث رسولا، بمعنى إنه أول شيء نبعث الرسول بيحدد زي المشرع بيعمل، and he decides what are the conducts that constitute crimes. So if you commit one of them, then you are guilty. If you do not, then you are on the safe side. That's what we mean by the and never would be punished until we send a messenger. This means that the Islamic Sharia adopted and embraced the principle many decades ago. Okay, the Palestinian Basic Law adopted this principle also in Article 15, which say the punishment is personal. العقوبة بتكون شخصية. The collective punishments are banned. العقوبات الجماعية محظورة, and this is what we need here. And no crimes and penalties without a legal text. No crimes and no penalties without a criminal. Okay, so the Palestinian Basic Law, it adopted the principle in Article 15. It says that no crimes and punishments without a legal text. Legal text means here any legal text. So all kinds of texts are okay here, whether they are constitutional rules or constitutional texts or ordinary text, whether the penal code itself or any other codes, what we call supplementary penal codes, or even auxiliary penal codes, auxiliary ones, and the regulations. So what matters here is that there must be a text. There must be a text, whether it is a constitutional or ordinary or even regulative one. Okay, so we don't care about the type of it. What matters is that we have to find a legal text. Now, let me move to the justifications of the principle. Why is the principle is important? Why to have the principle of the legality? Well, here he says that there are many justifications for having the legality principle. Number one, the political justifications. Number two, the psychological justifications. Number three, the logical justification. So let we start with the political justification. Why the legality principle is important. It says that being previously aware about the crimes and its penalties, according to the penal codes, will help the citizen not being a prey of his state, which may surprise him of crimes that he has never known before. Well, actually, this is logical, actually. If there is no penal code which names the crimes in the society, then if Ahmed Masood, for example, one of my students, he did something, I hate Ahmed Masood as a government, so I captured him, I put him in the jail, then I prosecuted and litigated him for merely doing something that is not mentioned by the penal code. However, Baha Barhum, for example, he committed the same thing, but I love him. I love him. So I did not do anything with him. Like, I didn't put him in the jail. I did not prosecute him or even litigate him. Now, simply because there is no name for the act that he committed, I mean, both Baha and Ahmed, then I can politically use the unnaming thing in order to fulfill my political desires. So simply because I hate Ahmed, I prosecuted him, while because I love Baha, I did not prosecute him. What makes me able to do such thing is that there is no names, there is no penal law which decides what are of the conducts that constitute crimes and what are of the conducts that doesn't constitute a crime. That's why, dear students, that we have to have the principle called the legality principle, or Nullum Crimen Sine Lege and Nullum Poena Sine Lege. So the person is not surprised with crimes that he has never known of them before. Okay, that's why the principle is important here in this regard. The psychological justification, it says that the principle plays an educational role, since knowing the crimes in a previous time will make the person think heavily before committing or attempting his crime. I mean, it will make me think twice before committing the crime, because I know what are the trouble that I'm going to face if I committed the crime. And the last one is the logical justification here. The rational logic supposes that the individuals must be previously informed of what is considered crime so that they can avoid committing them. So it's logical. You cannot prosecute me for something without uh, without alerting me that this thing that you are going to do, it constitutes crimes. So if you tell me that this act constitutes crime, then I will be aware and I will think heavily before committing this thing. Now, if I committed it despite the fact that I know, or that I knew before, then you have the right to prosecute me simply because I know about the crime previously. Well, this is all. I think I have nothing to add for this lecture. I end this lecture, and I will, inshallah, see you in the coming lectures, inshallah. In the coming lecture, we will be talking about the evaluation of the legality principle. Thank you for being patient. Thank you very much from deep of my heart, and goodbye.